My name is Marumo Mpomo. I am from the Department of Trade and Industry, and I'm going to facilitate today's discussion. I have a very august panel before me here. We have, to my right, to my extreme right, Dr. Tim Barrow, who's a long-standing intellectual property practitioner in South Africa, who's been the author of very important journals on various aspects of intellectual property for many years. He's got a very extensive experience having practiced with various law firms, including on his own account. And certainly he has a very rich amount of experience in the area of intellectual property practice for discussions. Similarly, we have Ms. Alison Dyer, also a well-known expert in the area of patent law in South Africa. Then to my left, we have Advocate Jonathan Berger, who practices at the Johannesburg Bar. Great expertise in various areas of law, but I think a particular very noteworthy contribution was that Advocate Berger was intimately involved in the very famous Hazel Tower and others case that is used internationally as a best practice on how competition policy can be used to facilitate access to essential medicines. Then on my extreme left, we have got Mr. Achal Prabhala, who is an author, an activist, and an expert on many things, including intellectual property. And he has got extensive experience working through the Shuttleworth Foundation, where he's a fellow, extensive experience working in South Africa, Brazil, and India. And he's been instrumental in many very important studies. And he also has been a contributor to this particular study, which we'll be discussing today. So, moving to the topic of today's discussion, this is a very important groundbreaking study entitled Innovation and Intellectual Property in South Africa, a Case for Reform. Now, it's the very first work that gives such an extensive analysis of South Africa's patent landscape over a sustained period of time, a 10-year period. And the conclusions that the paper draws using data garnered from the patent registry are very important. I think the crux of it, and I think one of the most important lessons that one can garner from this study is that maybe some of the assumptions around the role of intellectual property in the innovation ecosystem maybe should be scrutinized more closely. And I think we're very fortunate to have one of the authors, Advocate Berger, here to take us through how the paper was developed, how the research was conducted. Before I hand over to Advocate Berger, I think I'll just mention that we were supposed to have Ambassador Faisal Ismail with us as part of the panel, who was also going to be a co-facilitator. I used to be at the University of Cape Town in the law faculty on a full-time basis, and when I left, Ambassador Ismail took over from me in terms of the teaching that I did. And so I always joke that the students got a massive upgrade there. Unfortunately, today you've been downgraded from Ambassador to me, but nevertheless, he sends us his best wishes. He couldn't be here because something very urgent came up. But with that, let me then hand over to Advocate Berger, who will give us his views and key messages from the paper. Many thanks.
Good afternoon, everyone. Is this on? Okay. Not particularly used to being seated while speaking, particularly with a microphone in my hand. It's not how we do things in the courts, but this court public opinion might be harsher than any court I've appeared in for a while. I think. Are you doing it or not? Try that. No, this is better. The paper is divided into two parts. The first is the study that we did on the patent landscape, looking at patents over a 10-year period. And then the second is purely a desktop study of legislation and case law. Despite being legally trained, I don't plan to in this opening address to deal with the legal aspects, but certainly, and I know that Alison is going to be focusing on that, and so I will deal with that as and when necessary, and certainly in the discussion that comes later. But I do want to have a look at the first part in more detail, and for those who saw an op-ed that was published in the Business Day a week or two ago, if you read that carefully, firstly you'll notice that there's some errors that crept in, and those were of the editor's own making. So I don't apologize for those, but apologies if some of it didn't make sense. But I am going to largely base what I'm going to say now on that op-ed, on the parts that were correct. So to start, really the key question to answer is, why did we conduct this particular study? And really, my understanding was to get an idea of the potential impact on domestic innovation of amendments to the Patents Act that are necessary for ensuring access to medicines. So looking at what the draft intellectual property policy raises are a range of potential amendments to the Patents Act for issues dealing with everything from substantive search and examination to compulsory licensing, parallel importation, all sorts of substantive policy issues. And one of the issues that has been raised, or one of the concerns that has been raised, is about, well, that may well increase access to medicines, for example, but what does it do to innovation? We look specifically at what does it do to domestic innovation, given the reality that South Africa globally is a very small market, and that if one is relying as a multinational company on patent protection in South Africa, you're not going to be getting much of that global market. And so if to the extent that one can say that the patent system creates incentives to innovate, it's not the patent system of a country like South Africa that one would ordinarily look at. It would be the patent systems in the US, the EU, and in Japan, for example. So we wanted to look at, well, what is the potential impact of any of these types of amendments on domestic innovators? So what we did was we considered and analyzed a data set of over 4,000 patents that were granted in South Africa to South African individuals and entities over a period of over 10 years, so from January 2005 to July 2015. And the paper sets out, explains how we went about doing that. And when I say we, I don't actually include me, I include others who worked on the paper, in particular Andrew, and the research assistants that he had in trying to create the data set. The paper does explain that given the very limited publicly available information, or the information that is available publicly, it was quite a task to actually create the data set before even starting to analyze it. Importantly, the 4,064 patents that we considered constitute only 10% of all patents granted in South Africa, granted by South Africa over that period. So we're looking at a fraction of patents, 10% of patents being granted to South Africans. We then considered three questions in relation to the data that we had. Firstly, who are the South Africans who are getting the product patented? Secondly, what type of innovations or what type of inventions are being patented on? Is there any particular trend? And third, and I'll explain the reason why a bit later, are South African patentees getting patent protection abroad? And if so, which of these patentees are doing so? So, to start with the first question, who are South African patentees? And it's interesting, although I'm not sure where it takes us, but it's quite interesting that the single largest category of patentees in South Africa are individuals. My understanding based on the data is that has probably a lot to do with the depository system we have, and if you fill in your forms and possibly it's an oversimplification of it, but as I understand it, you put in the paperwork, you pay the application fee, there's no substantive examination of your application, and then you have your patent. And that may well explain why so many individuals are able to get patents. And as we find out through the paper, not that, as a percentage, not that many of those individuals are able to secure or seek patent and obtain patent protection abroad. So the single largest category of patentees are individuals, almost 45% of all patentees, then just under 40% of companies, then also looked at closed corporations, trusts, and then universities and research organizations. Universities were only 6.1%, and research organizations such as the CSR and MinTech only 1.6% of all of these. Remember, these are of the 4,064 patents. What I find quite interesting is that even though universities and research organizations only account for less than 8% of all of these South African patentees, they're responsible for the lion's share of what we believe are the potentially higher quality patents. And I'll deal with that when I come to looking at who is patenting abroad and some of the provisos to that conclusion, or the qualifications to that. We looked at the issue of gender. With only 9% of all of these South African patents having an identified woman inventor. And the highest rate for women inventors was amongst university patentees, 41%, and research organizations, 25%. Companies, 4%. So if you're a woman inventor, you've probably got a better chance of doing work that's going to result in patent protection if you work for the CSIR or for this university. We then looked at the type of patents, the type of inventions that have been granted patent protection. And here we compared the South African data generally with the data in relation to the 90%, the non-South African patents. And in the South African data, or the South African patentee data, there's no single blockbuster category. So if you look at the top 15 categories, and this is the broad categories, it doesn't get broken down because that information is not available. The top 15 categories account for about 28% of all South African patents. The single highest, largest category is 4.7% of all domestic patents. The next is 3.2 and then 2.19. And together these top 15 are 28%. So nothing that really jumps out. But when you compare that to the non-South African patents, you do see a single blockbuster category. The category of A61K, which are patents dealing in respect to preparations for medical, dental, or toilet purposes. This includes, but is not limited to, pharmaceutical patents. And that accounts for over 17% of all foreign patents. So, South African patents, 4.7% is the single largest category, 17% for the foreign-owned patents. That's 17% of 90%, which is 15.3%. So one category accounting for, we would say, is quite a significant chunk of all patents granted in South Africa. What we also did was we tried to consider the patentee-specific data from a different angle, and that was from field of industry. And we focused on patents that are apparently related to the potential innovation-rich fields of mining, business methods, security, explosives, and pharmaceutical products. This was a judgment call as to what falls within a particular category or not, because of the limited data. And the paper goes into some extent to explain just how poor the data is, the publicly available data. So it's quite difficult to determine what actually a patent is. There's no detailed explanation. You really just have the very often will be maybe not a judgment call, but more an educated guess as to where the patent can be properly, how can be properly categorized. One of the reasons we looked at that was because there's a perception that South Africa may be a world leader in key industries such as mining. And so right from the beginning of this paper, one of the things we wanted to look at was, what would, for example, be the potential impact on mining if the type of amendments that are being contemplated were to be adopted and would therefore have an impact, would apply to all patents, and not just to pharmaceutical patents, and the obvious impact there would be in relation to access, and I would say that nothing in relation to innovation, given that the bulk of the innovation is being spurred by patent system, patent protection elsewhere. But let's look at what may happen to the mining patents granted to South Africans. But of the 1,064 patents, we were only able to identify 290, or just over 7% as being mining patents. The conclusion we came to, based on the information, the limited information we had, and that's a big qualifier that I think applies to a lot of the conclusions, is that the identifiable mining patents are concerned with extraction rather than either exploration or beneficiation. So we admit that this may be a limitation of the patent data captured by the system, but we say that it may also indicate a mining industry focused on reducing operating margins on existing operations rather than exploration or moving up the value chain. One cannot come to a definitive conclusion based on the nature of the information we have. The pharmaceutical sector, which appears to account for a large number of patents granted in South Africa overall, remember, it's the broad category within which pharmaceutical patents are to be found, accounts for over 15% of all the patents granted in South Africa. But of the large number of those patents, South African innovators largely fared very badly. So of 49 pharmaceutical patents, we were able to find what we understood as 49, we were able to identify as 49 pharmaceutical patents granted to South African companies. Almost 45% of those were granted to universities, which outperformed all other categories of innovators. The numbers are quite small, so I'm not sure to what extent the percentage, how useful the percentages are, given those small numbers. Because of the depository system, so there's no examination of patents and the general lack of publicly available data, we were left with a few options, in fact only one option, to assess the quality of South African patents. I know Achille is going to speak a bit more about the issue of licensing, but our understanding was that one, if not the best way to assess the value of a patent is to see how much money it earns when it's licensed. And you just don't get that type of, we were not able to get that type of information back. So what we did was, and this comes back to the third question, we looked at whether or not the South African patentees were obtaining patent protection abroad, and if so, who amongst them was doing that. So just over a third of all the South African inventions in the data set have been patented in examining jurisdictions abroad. Companies hold the largest number of South African patents that have been granted in other countries, but on our assessment, publicly funded research organizations and universities are the most likely to patent abroad. When you
look at the percentage of their patents granted in South Africa, what percentage of those are also patented abroad in an examining country. Just to go back, it was almost 45% of all patents granted to individuals and about just under 40% to companies. But companies have hold the largest number of patents that have also been granted abroad. So once again, these are patents granted to South African companies that then also have protection abroad. So then coming back to the public research organizations, publicly funded local research organizations, in respect of their 63 inventions protected by patent in South Africa, 48 patents have been obtained abroad, so this is a 76% success rate. And in respect to the 246 inventions protected by patent in South Africa, local universities have obtained 149 patents abroad, just over a 60% success rate. It's difficult to tell, again, given the limitations of data, what exactly is the reason why are South African patentees not getting or seeking for both patent protection abroad. We think certainly the cost of securing and maintaining patent protection abroad is likely a factor, but so too probably is the quality of patents granted in South Africa without examination, and accordingly the patentability of those inventions in examining jurisdictions abroad. So it's one thing, for example, if a patent has been granted abroad and then is granted in South Africa without examination. It's another thing if it's granted here, it doesn't necessarily follow that someone will want to or will be able to secure protection abroad. So we come to the conclusion that the data indicate that the majority of patents being granted to South Africans may not be valuable outside of South Africa. And if they're not valuable outside of South Africa, it's more likely than not that they're not particularly valuable within South Africa. But valuable would mean valuable to the broader public, not valuable to the inventors. On this basis, we say that it's impossible to defend the status quo if you use the argument that the current system is needed to create incentives for local innovation, especially when it is this very status quo that limits access to the products of international innovation, such as life-saving medicines and other essential products. And then finally, we come to the conclusion that publicly funded research, the data on publicly funded research in South Africa, whether through research organizations or universities, what that shows is that it's not necessarily the patent system that is what is certainly the patent system in South Africa that is creating incentives, but it may well be the injection of public resources into those organizations and entities that is responsible for the innovation outcomes. Thanks.
Many thanks, Jonathan, for that excellent overview of the paper's findings. I gave the author the benefit of indulgence in terms of time because I felt it was important to really allow him to set out the findings. But I'm not going to do the same with the other participants. I'll be using a card system for the other participants. So with that in mind, Mr. Prabhala, in 5 to 10 minutes maximum, could you kindly then?
My name is Achal Prabhala. I'm a fellow of the Shatterman Foundation. I might refer to this as our paper only because I feel paternal about it. I ran a project that commissioned this paper and we published it. I was involved in early drafts, and so I'm very familiar with the work, though of course I'm not an author of the paper. What I'd like to do is to start with a couple of caveats and explanations from a broader perspective. And I'd like to say, first and foremost, that I don't think any of us researching this paper set out to own the term innovation or to fuse it permanently with intellectual property, as is sometimes done in the public discourse. So I think we, as probably all of us here, recognize that innovation is something simultaneously larger and more complex and intertwined with many other systems more than merely intellectual property. But our interest in researching this did come from an honest place because of the purported and real connections between innovation and intellectual property that are often mythologized or spoken of without necessarily consulting with the data itself. We felt that this was an opportunity to be able to say something conclusive about the state of innovation as measured by intellectual property on the basis of data, and not just a cursory look at the data, but a very thorough examination of 10 years of every single patent granted in South Africa, divided up by foreign patents and domestic patents. What I do want to say though is that we came to it from an access to medicines perspective, which is what we work on. And so, and while the conclusions reflect our concerns, we didn't set out to reach these conclusions. We set out to look at the data and to see where it would lead us. As it happened, it led us to conclusions which support access to medicines, and for that we're glad, but I do emphasize that it's the data that led us there, not the field of work we're engaged in. I want to talk about, very briefly, a personal journey on this. I've been working on access to medicines for about 15 years, and when I started working on this, I think, like many people, we set aside the subject of innovation. We thought of innovation and access to products of innovation as being things that need to be held in balance. And while this is true to a certain extent, this idea of balance, it's also overplayed. It's overplayed in the way that people think about a seesaw, with two opposing weights. On the one hand, you have innovation, on the other hand, you have access. I'm just being honest here, I think I certainly did think that this was a balance of that nature, and that my energy and time were best invested in access while ignoring the idea of what the effects of access could have on intellectual property and on innovation. But that changed, and that changed particularly in 2005 when India, which is where I'm from, implemented a dramatically new and original patent law, which, among many other things, set a reasonable bar for what qualifies as patentable innovation through the use of criteria, patentability criteria. I like to think of it, for those of you here who are not from deep within the discipline, as something like a high jump. There's a bar, you have to cross that bar in order to win a medal or to qualify. There can be a low bar, which is easy to cross, and there can be a reasonably high bar, which requires some effort and preparation to cross. In Indian patent law sets a relatively high bar. US and European patent laws set a relatively low bar. I think, unfortunately, our research in South Africa, not just an analysis of the state of patent data from South Africans over the last 10 years, but also the somewhat unjust and skewed legal system that surrounds the granting and administration of patents in South Africa, I think might suggest that the South African bar is not just very, very low, but possibly underground. And I think if you were to read the second section of the paper that Jonathan and Andrew had just produced, it would be hard to come to any other conclusion. What I have been thinking about while working on patentability criteria in India is an understanding, in a way, that in order to encourage innovation, it's important to set standards for innovation. When the standards are trivial, the innovation often follows. We don't have data to back this up. Indian patent law is 13 years old now. There are very few other countries which implement the same kind of criteria. It's not clear where this leads us in the future, but it seems fairly reasonable to say that if you set a reasonably high bar for what qualifies as government-protected monopoly terms in intellectual property, that you might, in exchange, receive something that looks like genuine innovation, as opposed to trivial innovation that's disguised and gets qualified according to the patent system that it works in. The second broad point that I'd like to touch upon is I'm neither an academic nor a lawyer, and I think therefore to be a little more blunt than both Jonathan and Andrew. And in reading through the many pages of the 60-page paper, or in roaming through the data, which we've also released publicly, by the way, which is under a public domain license on the accessibsa website, which is mentioned on the paper. If any of you are interested, as is the paper publicly licensed, it is hard not to come to an easy answer to the question, who does the South African patent system benefit? You know, in public policy, when people advance arguments and so on, one of the most important questions you can ask is, who's paying you? And in some ways, that provides a lot of answers in terms of the kinds of policies you're advancing. The patent system, as has been analyzed in this paper, it would suggest that there is really one category and one location of patents that earn rent. That category is pharmaceuticals, which when you combine A61K, C07D, a few of the other categories that pharmaceutical traditional compounds as well as biologics fall under, does take up the lion's share, the largest single category of patenting, and one location, not from South Africa, from outside South Africa, from developed countries, from the EU and from the US. And it is really hard not to come to the conclusion that there is one single beneficiary of the patent system in South Africa as it exists today, and that is multinational pharmaceutical corporations who are extracting rent on not just any kind of products, but products that keep people alive. I think it's important to remember that a blunt distillation of the data and the analysis that's contained in this paper will lead you to the same conclusion. The very last point I want to address very quickly, if I may, in a minute, is one of the favorable conclusions of the paper that Jonathan and Andrew have written is that in their view, from the data that's available, the patents that do best in South Africa are patents that come from universities and research institutions. So this is UCG Medical School, this is the CSIR. These are large publicly funded research institutions that work on medical and other technology. Now, how did they come to that conclusion? They came to that conclusion on the basis of their success rate in exporting the same patents from South Africa overseas. That's a limitation of data, because one of the pleasures of working in India and South Africa and Brazil is a confluence of institutions and structures. So for instance, you have a CSIR, we have a CSIR. It's exactly the same kind of institution. It's a large publicly funded research body that does publicly oriented scientific research. I've been researching the CSIR in India for a fair amount of time, especially as it comes to patenting, and there are some interesting things that happen there. One of the best tests to determine the value or the quality of a patent is how much it's licensed for. It's the cold hard cash that it can generate, and the extent of time that it can generate that cold hard cash. We don't have data on if and how much licensing agreements for any domestic patents, but especially patents from public institutions in South Africa exist. We do have that data in India, and what it suggests is that perhaps the patenting system itself is creating a perverse incentive. And I'll tell you what I mean by this. CSIR, over the last 10 or 15 years, ran a patenting program that was relatively unchecked. Over a 10-year period, they invested something like $50 million, publicly disclosed, on securing patent protection for over 4,000 products in India and around the world. As you can imagine, the bulk of that money went to engage expensive law firms in New York and in London and Brussels to file patent applications at the European and US patent offices. We queried the CSIR as to, in exchange for this $50 million, how much licensing revenue it had generated. Their answers were coy. They said that they had signed between 50 and 100 licensing agreements, all within India, no international licensing agreements, so no country outside India. And mind you, CSIR had patented through the Patent Cooperation Treaty, which you can now do very easily, many of their products to be patented across the gamut of the 150 countries that you could patent in. So literally everywhere from Algeria to Zimbabwe. But there was not a single foreign licensing contract in place. There were some domestic contracting licenses and zero revenue to report. And so it's to the extent that we suggest that patenting in foreign countries suggests, because of our location in South Africa and because of the depository system, there is a suggestion that therefore patent protection in the United States, secured in the European Union, is superior to what you can get here and is evidence of innovation. Because India has this strangely advanced patent law, a subject that is very close to my heart, for instance, is our current right-wing Hindu government's obsession with cow urine patents. And if you want to know any more, look it up under my name, and there's a lot more. But cow urine patents that have been taken out by the Indian government through CSIR exist and are enforced, to the extent anyone cares, in every country, from the United States to every single European country to several Asian countries. There's one country in which they cannot be enforced. That's India, because we ban various kinds of trivial innovation, including known uses of traditional knowledge. And one of the astonishing things about CSIR's innovation is that not only are its cow urine patents banned in India, they are also of zero value to date. After 10 years of paying law firms and maintaining these patents in all of these different capitals in rich countries around the world, they generated zero. And so a profit and loss audit of CSIR's patenting would say it's not worth it. And that's exactly what happened. So last year they actually shut down their technology transfer office that was seeking to patent because it just wasn't worth it. It wasn't generating any revenue. What it was doing is advancing the careers of several people associated with those patents and managing those patents. And I bring this up only just because I'm speaking very much so, of course, of CSIR in India, not South Africa, but is the future scenario, I think that's worth considering. It's not a current reality, but it's possibly a future hazard, and it's something that we were discussing. Thank you.
Thanks, Achal, for those very concise points and for bringing the comparative perspective. And important to note, ladies and gentlemen, when he mentioned CSIR, Indian CSIR, not South African CSIR. Dr. Brown?
Thanks, Peter. I'm not going to make comparative analysis of systems. I'm not prepared to speech or anything like that. I'm not going to make comparisons with other legal systems. I just want to get down to what is written in the article and what is to be reported in Business Day. And in your article in Business Day, Jonathan, you maintain that the South African patent system is not encouraging of innovation. And you there contend that South Africa's existing patent law stifles rather than stimulates invention. You go on in your paper to discuss the South African patent law embodied in the Patents Act with particular reference to certain sections of the Act, which I'll come to discuss more fully in a moment. But in short, you ask the question, does South Africa's Patents Act, as interpreted and applied by our courts, encourage invention? And your answer to that in your paper is no. The question which you pose to answer is thus predicated upon the premise that that South African patent law, as embodied in the Patents Act, is designed to encourage invention, but that it fails to do so. That's the premise, that's the fundamental assumption. Now, with respect, that premise, that fundamental assumption is incorrect. South Africa's patent system is not designed to encourage innovation. Never has been. A patent represents a quid pro quo. What happens, what the quid is, if you put it that way. The quid is the monopoly conferred upon a patentee for a number of years. The quo is the new knowledge which he or she represents to the public and which after the expiry of the patent it passes into the public domain. It's a deal. It's a deal between the inventor and the state. Here's a new idea. It's going to become yours after a period of 20 years. In the meanwhile, during the course of that period, you grant me a patent. Now, the South African patent system, as embodied in the first instance of the Patent Act, is therefore to provide a legal framework for innovative disclosure in exchange for reward, to govern the rights of patentees, vis-a-vis the state, vis-a-vis the populace. That's all. In short, the patent system is not designed to encourage innovation as you would have it, Jonathan, in your paper and in your article. There are doubtless very many factors which stifle rather than stimulate innovation outside of the South African patent system. But such factors are not to be found, or rather are to be found, not inside the patent system, but outside the patent system. There's the Intellectual Property Rights for Public Equity Finance Research and Development Act, for example, or the Medicines and Related Substances Control Act of Section 25. There are these many sections which are available, but not in the Patents Act. There's absolutely no reason to disrupt the system as it stands. Now, I haven't prepared a paper as I should perhaps have, but anyway, I haven't. But let me just deal with the first section of your article, in fact, the very last few pages. You consider and analyse, you say, the relevant statutory framework in the penultimate paragraph of your report. The argument is that the existing soft application procedure gives rise to patents of undue rights vesting in a patentee. A case for reform is warranted. The rights vis-a-vis the innovation are not good enough, and so the argument proceeds. And the system is skewed in favour of the patentee. Now, the patentee's rights are set out in the Act in Section 45, but they are restricted by a number of sections. For example, a false statement by a patentee, by the applicant for a patent rather, in the application form leading to the grant of the patent will result in the invalidity of the patent. The patentee's rights are limited strictly to the scope of the claims of the patent specification. What is not claimed is disclaimed. There can be no broadening of the claims of the patent before or after grant. The limitations of applications to amend or correct are strictly curtailed in the Act. Payment of renewal fees are payable. Renewal fees are payable rather. And if failing which the patent lapses. And if it does lapse, then the restored patent it comes into operation, but the person who spent any time and money on the expenditure of the relevant innovative material is entitled to compensation. A patent can be revoked on a wide range of grounds. The patentee's rights to bring proceedings for infringement of the patent are subject to a 9-month moratorium. In other words, for the first 9 months, he can't bring any proceedings for the infringement of the patent. And there's a good reason for that. And that is that the search engines throughout the world will examine the sort of subject matter with which the patent is concerned. I was dealing with infringement, and I was saying that I I should have said, perhaps I was going on to say, that provisions for a counterclaim in any infringement proceedings are available. Special provisions are made for field trials while the patent's in force. An application for a declaration of non-infringement can be brought at any time. Specifically, a declaration by an interested party is also available when a patentee threatens infringement proceedings. The rights of the patentee are deemed not to be infringed by the use on board of a convention vessel or aircraft. And there are services, search services, which are on offer right now. There are innumerable, not innumerable, there are many search engines, people who provide searches which will determine whether or not a given patent is valid. The minister may require certain inventions to be kept secret. There are lists of conditions which are excluded from contracts relating to patents, and so on, and so on, and so on. That then ends to a large extent what I wanted to say, but perhaps I should just go on to discuss the concluding paragraphs of the paper. That is paragraph 1. You there consider, I'm dealing with the last page relating to paragraph 1. Thereafter we consider and analyse the various statutory frameworks governing the grant and management of patents in South Africa, and how it has been interpreted and applied by our courts. In doing so, we show that the domestic landscape is characterized by the seemingly easy grant to South African individuals and bodies of patents of dubious quality, and that the patent system is heavily skewed in favour of the patentee. Now, no mention is made of any of the sections, or perhaps one or two of them, that I've mentioned, which I've listed. I'm then going to now turn to the paragraph which is number 2. That's the analysis of scientific analysis, which I'm not really competent to discuss. But let's look at the key finding. Paragraph 2.5. The discussion then is the first sentence, which I won't bother to read, but then it's the second sentence of paragraph 2.5. If this is so, then it becomes impossible to defend the status quo on the basis that it is needed to create incentives for local innovation. But that's a complete non sequitur. It is not contended that the status quo is needed to create incentives for local innovation. It's not advanced. I'm then turning to I'm going to then jump straight onto the last page of paragraph 3, the legal framework. And I don't want to be unkind, but there are so many errors in this that I think that we could perhaps deal with them in some other forum almost, because it'll take me many minutes, many hours to go through all of these things. But the conclusions which are drawn are often not correct. Let's just take the last page, which is of paragraph 3. It says that Form 20 makes provision for one thing and another, and regulation 89 indicates Form 20 is to be accompanied by a statement of particulars on which the application is based. Significantly, no provision is made for the filing of a founding affidavit. This is in revocation proceedings. No provision is made for the filing of a founding affidavit. Well, Regulation 92 provides, within 2 months of the lodging and service of the counterstatement, the applicant shall file and serve his evidence in the form of an affidavit. Exactly the opposite of what is there stated. An application for revocation is interesting because it starts off in the form of a plea. Then 2 months is left or required within which a patentee is to deliver a counterstatement. So there's the view. And so that's sort of the governing, almost equivalent to pleading. Then a 2-month period is allowed for the applicant to file a founding affidavit, and then the other side, the respondent will file a counter affidavit, and so on. So in other words, it forms the usual procedure which one follows in application proceedings in the Supreme Court. It's a bit of a hybrid system, but it works. It works extremely well. Very often these things are able to be decided on paper, on affidavit, rather than going to oral evidence. And very often applications are 1 minute to go. I'm sorry, all right. Well, let me just then go to the final paragraph, which is paragraph section 4. The mention here is made of lucrative licensing agreements that you will see. I don't know how they're known to be lucrative, but one would expect in the second paragraph of the conclusions, paragraph number 4, one would expect a patentee who's a party to such lucrative licensing agreements to record the income generated from its patented inventions. Why would a patentee want to do that? And this is a private business deal between the patentee and the licensee. In the first paragraph, under paragraph 4, the first subparagraph, this is despite section 10 of the Patents Act, which appears to require the recording of such information in the register. It requires. It doesn't do anything of the kind. There's no such requirement. Section 10 makes it optional to file a copy of the license agreement, and section 17.5 makes it advisable. But there's no requirement. And there shouldn't be. Why should there be? That's it. Thank you.
Many thanks, Dr. Burrell. I think you've given us quite a lot of food for thought and discussion during the question and answer and discussion period that we'll have after the last, but certainly not least, presentation of Ms. Alison Dyer.
Thanks. I will admit up front that I'm a patent attorney in private practice, therefore what I have to say obviously comes from that background. Secondly, my other failing is most of my work is in pharmaceutical patents, so take that on board before I start. However, I am personally in favour of substantive examination, and I believe it's time that it is introduced into South Africa. So although I'm going to be critical of the study, please don't misunderstand. I definitely think that we should reform the Patents Act to introduce substantive examination and opposition proceedings and various other things. If we start with looking at the data, unfortunately the data which is being used was never intended for this purpose, and I think that is its fundamental weakness to begin with. This data was, or has to be presented by patentees for various reasons. There are requirements in the Patents Act that you identify the applicant, the inventors, the title of the invention, that type of thing. The patent classification is there to assist in patent searching. It was never intended to provide a data set which could be analysed, as has been done, to draw conclusions. So I think that is a fundamental weakness of this whole thing. Secondly, there are other problems with what is stated about this data. For example, section 2.3 is headed Nature and Quality of Publicly Available Data. But what actually is meant is publicly available electronic data. All patent files are available at the Patent Office for scrutiny. They're open to public inspection. You can obtain all the information you want about the patents, but it's not electronic. Even the electronic data which is available is not referred to in the study. For example, for some years now, the Patent Journal is being published electronically. The abstracts of all granted patents are published in the Patent Journal. Therefore, for example, with the patent that is specifically dealt with in the study, the transducer patent, it would have been quite available for the people carrying out the study to consult the Patent Journal and find the abstract of the patent. They didn't need to look to the Australian system to find that. So far more data is available than is stated in this study. I think the next thing I would like to say with regard specifically to the transducer patent, that patent was filed through our firm. Now obviously I'm not going to say things that I shouldn't, but there was a whole strategy behind the filing of this patent. And according to the person in our firm who dealt with it, it was a strategy which is probably only adopted twice in his 15-year or more career. To pick on this particular example and then draw conclusions is simply not correct. It is one out of many patents, and it had particular reasons for its existence. I don't think then you can draw any conclusion from the fact that it was filed as an Australian innovation patent. Those are often filed for reasons of speed because you get them granted more quickly. And cost. And cost is a huge factor. Patents are expensive. So even the authors of the study admit that there is a paucity of data, and the data which there is open to interpretation. So I think it's unwise to place too much reliance on the conclusions drawn from the starter. It's simply not robust enough. Having said that, I do believe that patent protection is important, but it is only one plank in the platform supporting innovation, and local innovation in particular. So while it has to be there, it certainly is not going to be a driving factor. When we then get to the legal framework, I'm afraid I'm like Tim Burrell. There's a lot of errors in what is stated. I think the starts with the opening sentence, which says that the legal framework is heavily skewed in favour of patentees. It sets the tenor for what follows, but what follows is often incorrect and often ignores contrary arguments. To give some examples, there's a section on patentability criteria, but no information is provided on the restricted criteria which might be used, so it's impossible to comment further on that. Then there is a section on parallel importation, and while that is not specifically provided for in the Act, there is in fact, case law which allows for parallel importation in the case of Stafford versus Akakura, which specifically stated that when a patentee sells a patented article, the article is free from all restraints which the patentee's monopoly had imposed upon it, allowing specifically for parallel importation. Then if we go on to the section which is said that South African patent law is stacked in the patentee's favour, the first bit is about onus to prove that a patent is invalid. While this is true, I think it ignores what happens in practice. In our practice, we strive to ensure that any case we file is valid before it is granted. This is achieved by considering prosecution in other examining countries and other validity issues and making the necessary amendments before the patent is granted. In our particular firm, we remind applicants of the need to amend when we file, when we review the case, when we advise on acceptance, and when we give them notice of acceptance. So at least 4 occasions, we tell patentees amend. And in fact, they do. I had a look at my own caseload, and for the last 9 months, of 95 cases of mine, which admittedly all come from abroad, which have gone to grant, only 4 have not been amended. So the pattern is to amend, to make sure that the patent which is granted is valid. It is not simply a case of filing and saying it's registration, you don't have to worry. I do acknowledge that the system is applicant-driven, and the patent applicant will obviously only amend to the extent they feel they have to. And it will be much better when there is substantive examination so that there is a balance between what the applicant is prepared to do and what he should do. The next is section heading continued validity of patent found to be invalid in infringement proceedings. While it's correct that if there's no counterclaim for revocation, the patent remains on the register, it would be an incredibly foolhardy patentee who sought to enforce a patent which had been found to be invalid. I mean, you would be slapped down so quickly by the court, it wouldn't be funny. So it just is not going to happen. Next thing was a question of amending a patent specification when its validity is under attack. Again, it's true that the court found that the provision of false reasons was not a jurisdictional requirement, but was a factor to be taken into account. Again, it would be a foolhardy patentee who did not provide full reasons, and I know of no case where reasons were not provided. But in any event, the absolute majority of applications for amendment are filed to the Patent Office, where the provision of full reasons is a jurisdictional requirement. So this is really a nothing. Then there's a section on effective recognition of contributory infringement, and this is criticised. However, I would like to just make one comment on the Cipla MedPro case, which is quoted in the study, and I would like to counter with this quote, which is that, said by the judge, nonetheless, it is clear that Cipla imports and supplies its products with the direct and sole intention that the act of infringement should occur. Indeed, the insert that accompanies the product directs health workers to use the product in that way. This was not an innocent company importing 2 unrelated products which then you could put together. They had, as was said here, the direct and sole intention that they should infringe. if I can go on to other things. And particularly, I would like to give certain of those provisions, to mention some which are contrary to the interests of the patentee and which are really relevant to what was said prior to this. The first is that if in any proceedings for infringement, one claim is found to be valid and infringed, but another is found to be invalid, the patentee cannot get any relief on that valid and infringed claim until the invalid claim has been dealt with by way of amendment. And as applications for amendment can be opposed, that can result in considerable delay in obtaining relief for infringement. Further, the court has the power to decide from what position in time damages will be granted, and can decide that where a patent has been amended, the damages should only be awarded from that date of amendment. They have similar powers with regard to the costs to be awarded. And finally, one mustn't forget the two Lundbeck cases. In this case, a court declined to allow an application for amendment where the patentee had delayed in making the application for amendment for a considerable period of time. The result of that was that the patents were unenforceable. Despite the fact they covered good and important inventions, they were unenforceable. So all of that is a counter to the idea that everything is skewed in favour of the patentees. So my conclusion is that I don't believe that this study is an accurate picture of the current patent system in South Africa and shouldn't be used to justify amendments to the Patents Act. Having said that, though, I do believe it's time we do introduce substantive examination and other legislative measures, which will be to the benefit not only of South African patentees, but also foreign patentees. Thank you.
Thank you, Ms. Dan, and I want to thank you for being very concise and keeping to time. Now, ladies and gentlemen, I think there's a lot of food for thought and food for discussion that has come out of the interventions from the panelists. I also want to ensure that there's ample opportunity for the audience to participate. So, as facilitator, I'm going to proceed in the following way. I'm going to highlight some key aspects that I think came from the last two presentations, and I will ask the author, as well as Mr. Pravala, where relevant, to also come in on those three aspects. And then from there, we can have more of a discussion between the panelists and the audience. So I think, and Alison, I think also please also do come in on some of these aspects. So I think firstly, the first key aspect that I think Dr. Barrow rose, which I think is quite fundamental to what the study tends or tries to achieve, is the role of patents and innovation. And I think there was an interesting assertion from Dr. Barrow to the effect that patents are not meant to stimulate innovation. It's merely a quid pro quo to provide a monopoly in exchange for incentivizing disclosure. So it's not about actually incentivizing innovation. So I think if you could address that first aspect, Jonathan and maybe Alison, we didn't hear your perspective on that particular aspect, so it would be good to hear your view on that. Then Jonathan, specifically for you, there was from both respondents, I would say, some comments about the data set. And I think more poignantly pointed out by Alison, she raised some concerns about the data set and whether or not appropriate use of data was made. So if you could maybe elaborate on that aspect. And then there were, a lot of points made about some aspects that were deemed to not be correctly interpreted. There's obviously inadequate time to ventilate each of them, and I think we might lose the majority of the audience. So maybe let's focus on, and Alison, I hope I'm not mischaracterizing you, you'll tell me if I am, but I think a very important one was that you seem to take issue with a view that the current patent system tends to incentivize patent or filing patents which could be considered actually valid in terms of the patentability criteria. So could you maybe discuss that? Do you think that you maybe could address that particular concern, and maybe in your view, how is it that the patent system does tend to encourage the filing of patents that could be considered invalid? So if you could start with the first aspect on the purpose of patents in relation to innovation.
We both want to deal with that issue. I think we can. If the patent system is not, if the standard patent system is not designed to stimulate innovation, well then what? There is nothing standing in the way of the DTI from embarking on at least from a public policy perspective, embarking on a brutal amendment of the Patents Act. If we accept that, my understanding of the patent system globally is that it's precisely, let me try the other way. The justification for the patent system, often advanced by multinationals, and certainly in the pharmaceutical sector, is that but for the existence of patents, we would not invest I'm not sure what the number is now, $1.something billion, what that amount is. We would not invest that in innovation. And that is the line that has been punted for years and years to justify. If that is not correct, well then there's nothing standing in the way of government. If government says, well, the public interest is best served by ensuring access to the products of innovation from wherever they may occur, provided we don't go further than what we're obliged to do, provided we do what we're obliged to do in terms of international law, we're not going to go one step beyond that. So we would be quite generous in saying, well, let's examine that premise and see where it takes us. But if you're saying to me that that's not what the patent system is designed to stimulate, then I'm saying the patent system is a free-for-all. It's open to wide-scale amendment.
Yeah, I think this mic is not working. Is it? Yeah. Tim, I was intrigued by your opening remarks, and you were quite frank and brutal, and so allow me to be as well. I do find this interesting that you started off by saying, well, look, I mean, the whole premise of this paper is off, and so essentially we don't need it. Because, I think in many ways we would prefer that scenario too, if that was actually true. But I think honestly, either you've not been reading any article defending intellectual property and the status quo in South Africa, or they just pass by you, because from our perspective, or from my perspective, let me just say, there is a continuous onslaught of opinion pieces, several by people who are intellectual property experts, but always, not necessarily some economists, who consistently warn that tampering with the intellectual property system, whatever that is, the status quo in the United States as it is today, the status quo in South Africa as it is today, means that tomorrow the sky will fall. And specifically, the sky will fall on innovation. There is this idea, this is not our idea, this is an idea that's very much a staple of public discourse on intellectual property, that this is a finely tuned system. And it's always that the system as is, wherever it is perfect, and it's perfectly tuned to innovation, which presumes that there are all these people innovating using intellectual property as their basis and incentive. And that tampering with that to create stronger patentability criteria, tampering with that to look honestly and legally for ways to increase access to medicines will cause that entire innovation ecosystem to crash. And that's what
this paper was a response to. So it's not us stating that this is a premise, but this is us stating that this is a publicly understood premise that we wanted to investigate further. I think, and with respect, as Jonathan said, in some sense, I don't think we feel that the intellectual property system is completely dissociated from innovation. I think that on both sides, sometimes the case is overblown. I think that have been people who want access to medicines who would have you suggest that the intellectual property system as a whole has absolutely no effect on innovation. And I think that there are several others out there, very powerful pulpits, who want you to say that it is entirely dependent, innovation on intellectual property. I think that the approach that this paper took, in my opinion, is much more honest and exploratory to examine what these connections are. In an honest way to look at the data and then see where the chips fall. Jonathan?
Alison, if you could make a comment on that.
Okay, well, it wasn't my point, I didn't really say that. I actually said that patent protection is but one plank, and I still believe that. But there are other reasons why you have patent laws and patent protection. For example, the South African government is very keen on local manufacture of pharmaceutical products. You're never going to get that if you don't have patent protection for those who are going to set up factories to manufacture those pharmaceuticals. That's not innovation, it's investment. So innovation is part of one. And I can make an argument with what?
Why do you need local patent protection for manufacturing?
Because otherwise somebody will just put up one of the next one you can say without the requirement to pay a license fees or whatever. I mean, let's look at the simple case that you quoted. Why was simply importing this medicine into South Africa? Certainly not for public benefit, it's to make money. You know, infringers aren't good guys. Or typically. They are to make money together.
I mean, I would argue that certainly Cipla's primary goal was to sell medicine, but I would also argue that the public would benefit from being able to purchase cheaper products. And so while that may not have been Cipla's intention, it would certainly have been its effect. But I mean, the counterexample, I mean, the argument that you need patent protection to have local manufacture. The two arguments in response I'd like to make. The first is that the Patents Act expressly recognizes that local, as interpreted by our courts, that local working can be done by way of importation. If the local working requirement, that would be a certain way to ensure domestic production, would be to say that local working can't be satisfied through importation. One would have to produce locally. The second is that, as far as I understand, Switzerland, pioneer is the correct word, but in the industry, only adopted pharmaceutical product patents quite late. Certainly long after local innovators had, such as Hoffman and Roche, were quite advanced in the industry. So my understanding is that provided, on the assumption that patents are necessary for innovation, provided you have patent protection in the markets that matter from a commercial perspective, that's what you need. Patent protection in the markets that are marginal from a commercial perspective are not going to advance that.
Good, thanks. So I'm going to take Alison's intervention to rather mean that maybe she, in her capacity, doesn't take issue with the view that the purpose of patents should be to stimulate innovation. I think I can take it from what you've contributed, that you don't take issue with that particular perspective. But in the interest of time, I think let's move away from this question. But of course, I'm going to allow Dr. Barrow to maybe come back if he has anything to say on that. But before we do, I want to just allow Jonathan an opportunity to speak to this, to the second aspect, the issue that was taken with regard to the data and how it's being used.
In relation to the first part of the paper or the second part of the paper? The data.
The first part, the data. The data set. Because Alison was of the view that the data that was made reference to was firstly not meant for this particular purpose or this kind of analysis. That's the first thing. And then the other one she mentioned was that there was data available domestically which could have been made recourse to, which was not. So just a general, that's what, those are some of the observations of Alison. So just some, if you could maybe give your response to those concerns.
I'm going to start, if I may. I was involved with Jonathan and Andrew as they were writing the paper in the securing and the sorting of the data, so I have some of the details, but not all. I take your point that not all the data that is necessarily useful for purposes of an analysis like this is available electronically. And unfortunately, what we say to that is exactly. The reason being that I think there is we have to very seriously consider different ways in which this data can be analyzed. So even the available data that we received was a combination of workings with DTI, was a combination of adding and subtracting and cross-checking with several proprietary databases which we had temporary and unusual access to. I do think that in acknowledging your question, we must also acknowledge that the data management around patents in South Africa, as in many, many other legislations around the world, is terrible. It is designed, I'm sorry to say again, in order to benefit a particularly small set of people who are skilled in navigating the paper and electronic data that is available around patents, such as patent attorneys or people who deal with applications for domestic and foreign companies. It is not designed to be researched. And so when you say, and I understand you agree with that, but you understand what I am saying, which is that not only is it not designed to research, it is actually designed with a shield against research analysis of the kind that we were taking. So I would prefer, rather than pointing out to the extent to which we did not look at complementary paper data that could have added a degree of more information around a certain number of patents, including what you mentioned, the transducer patent, around which we had some correspondence with CSIR. I would say that I'd much rather focus on how we can make this data more publicly available for analysis and use by the South African public, who in many, many ways is paying for this data to be created and paying in many other ways for the medicines they take every single day through this patent system that they're actually not even allowed to as lay people, as experts, as researchers like us. That, I think, is a much greater problem than having left out a few pieces of paperwork. But having said that, I think that there is an enormous amount of information that can be gleaned. We've used many of the same techniques as we've used here to analyze the patent data available in India and elsewhere. And consistently battling with the same sort of paucity of public information, which I do think is egregious. This is a system funded with public money based on public trust that eventually funnels private money out through a public system, and for that data and information around it to be essentially unavailable, except with great amounts of care and asking and time and money, I think is egregious. But there is a substantial amount of information. We haven't overreached. What we've done is to analyze the data in the best way that we can. I very much doubt, given the manner in which claims are made, in the manner in which applications are filed, I do appreciate the quid pro quo point about disclosure versus monopoly protection. But there's disclosure, and oftentimes the disclosure is actually not necessarily written in any kind of lay language, or designed or written in such a way in order to be understood or mapped to a product or an industry very easily. So we use
the same kind of categories that everyone uses for the analysis of patent data. We look at A61K, we look at C07G to try to identify pharmaceuticals. Would we have missed 4 pharmaceutical patents? Absolutely. Are we confident that we have analyzed and found and researched the overwhelming majority of the categories we were interested in? Absolutely too.
I just wanted to touch on that transducer patent. Because I think, I'm not saying it's your intention, but the way I understood, it seems as though you're suggesting that we may have deliberately looked for an outlier.
No, sorry, that was
Oh,
my
okay.
intention.
But if I can just explain how it came about, and actually, Andrew was the person who had used that as an example, and I understand it was a truly random example. He then had looked at the Australian database, and at that point, what the paper was looking like was comparing the amount of data information available, the South African information we had versus the Australian information. I had done some work prior to that on innovation patents in Australia. I worked often could be referred to as utility models elsewhere, as opposed to a standard patent, which is the full patent. And when I clicked on the link and went to the Australian data to look at it, it struck me that this was an innovation patent and not a standard patent. And so that was kind of how the process internally worked. So it wasn't we didn't identify it as upfront as an example of a product that had full patent protection in South Africa and limited protection in Australia. It was actually quite by chance that we stumbled upon that. It was truly a random example with all the information from Australia, and part of that we saw, well, actually it's only got the 8 years of protection there as opposed to the 20 year.
Sorry, can I just say?
Very briefly, please.
I wasn't suggesting that you did it on purpose. I'm just saying that you cannot pick a patent and then analyse it like this and come to a conclusion, because it is an outlier. Now, you can know that particularly, that's not the point. I'm just criticising what happens if you pick a patent and just look at that, and in isolation of outside information.
If we can, the thing is, I think we can go, back and forth on this, but I think the main conclusion that we can draw on the data, and I think we've had some good discussion on this, is that economists always often speak of perfect information, and that scenario only exists in an economist's assumption. That's the only place or the only time we will have perfect information. I think that the authors made use of the best information available in as innovative a manner as they could. And of course, I think the contact details are available, so if there's any further questions about the methodology, that can also be taken up after the fact. But I think since we've got a very, very keen audience here that really has honored us with its presence, I want to give an opportunity in these last 15 minutes before we move on to giving the panelists one last word. I think let's take some questions from the audience. I would like to take 3 questions, and then if we have time, maybe we might take another round. But let's just have 3 questions from the audience. So we'll have Professor Jonathan Aaron.
Okay, so I guess I want to make 3 points, which may be in comments or questions. I think the first is that I welcomed this research, and I think for a couple of reasons. I think one, the premise, and which I think is part of the research design, is actually making a distinction between domestic innovation and some of the questions there, and the transnational global system. And I think that's very important, partly because we talk about, in sort of slightly more broad terms, national systems of innovation, but I think South Africa and where it plays within the world is a very important point here. So the research, I think, really goes to that, and I think some of the comments do. As I understand the research, it's maybe sort of very broadly speaking, socio-legal, in the sense that it is trying to put together certain analysis of a legal system, understood in legal terms, together with statistics and research in that sense. So it's trying to put, to some extent, two bits of research together. I'll get to that in a minute. And I think what it's doing is engendering a debate, and there's participation. And I and the other members of the audience have just seen a lot of that debate amongst the panel here. So I appreciate that, and I appreciate the participation by kind of all sides here. The second part is just, on the patent legal system, I think some of the discussion here has been, I mean, I am a legal academic, but I'm hardly a patent expert or even academic. And while working in areas of the law that are close to this, I think that effectively maybe, I think Burrell's pointed out, there's another forum to look at some of the sort of more legal questions that have actually been brought up. You know, that may be very appropriate. And I think there might be lots of places to do that, and we can look for it. The third point was around the data direction. So I'd be interested, doesn't actually have to be necessarily tonight, but later on, I'd be interested for observations and ideas about where the data, what further look into the data one would want to have. Ms. Dyer, you were seeming to, you're on top of the data. You know the paper as well as the electronic. And you're saying these questions are not, in your mind, well answered, you know, but is the data out there to do studies that would do that? Or do we need to look in different kind of ways, into doing kind of case studies or more analyses of how the patent system actually works? You can understand a certain amount of suspicion from the outside when patent lawyers say, wow, it's working fine. But, you know, it may take a little bit of closer examination for it. And Maruba, I'm sorry, but actually DTI comes under a little bit of critique here too, because I would be interested to know if the problems with the data are not only, if they go deeper than what is made available under the paper or electronic, and if it actually goes into the kind of statistics or data that we are collecting. And oftentimes that's, you know, has to be external constituencies for particular purposes like redrafting an IP law or framework that says we need certain data that we actually don't yet have.
I'm currently a student and a part-time co-founder of a startup, so we're really interested in, I'm currently a student, computer science student, so we are generally interested about protecting our intellectual property. But the question that I had, the comment that I had was with the data itself. It seemed as if, especially the comparison, it seemed as if to me that there's certain unique situations that South Africa has, and then extrapolating that to an international setting would then be skewed, because South Africa has a certain qualities in itself. It has a certain, some people term it a combined uneven society, whereby not the major representation of innovation is limited to certain quarters of society, particularly with research in the universities. But with the law itself, I would support the law to have the most strenuous criteria. But then, from a first-hand experience of trying to register some intellectual property, I wouldn't say that the current intellectual property laws are in favor, because, again, I say it tends to favor certain parts of our society. So, if the laws itself were to be amended to make it more stringent, I think it would be also worthy that the support mechanism that actually assists people to get on this and to understand the new and the laws. And then the last one is just really a question, is that since we're moving into the fourth industrial revolution, so how do these new IP laws then be integrated into this new space that we're working? Because all of a sudden, your IP now is not something physical or something, it becomes something that's something, maybe it's intangible, something like a code and something like something relevant to the new spaces that we're moving in. So it's also a bit of a question of how do these new laws also address the time that we're living in, especially when it comes to the economy.
And your name was? Leo, thanks Leo. And then I'll take, for now, the last question from Zen, from section 27.
Thanks for introducing me, I guess. It's more of a comment and to refer back to the kind of rationales for intellectual property. I think it's worth having a conversation about, measuring both the benefits and the cost of the intellectual property system, right? So there's, typically I see four rationales for IP. You have the first rationale, which is kind of the classically criticized rationale, is that we need intellectual property because the people who came up with it somehow deserve it, right? And this has been kind of widely criticized, and people say that knowledge is like an ocean. Just because you pour like a can of tomato soup into the ocean doesn't mean that suddenly the ocean is yours, right? So just because you contribute some idea doesn't mean that idea is suddenly yours to the ocean. The second one is disclosure, which was mentioned, which was kind of, it's a quid pro quo between society. We don't want things to be kept as trade secrets, so we want to know what and how we make that invention, which was the point raised. The third was the kind of classic innovation, we need IP for innovation, and the fourth is kind of, maybe in the South African context, we need foreign direct investment, without IP, companies won't come here. But then, it seems like some of the panelists discount the innovation argument, that IP is not for innovation, and we know that the kind of labor argument that, they earned it is no longer relevant either. So it seems like, really, the benefit IP then is about disclosure, which is kind of striking because you also have to compare the costs, right? And I don't mean the costs necessarily in an economic sense, but if you look at, what is the cost of IP in South Africa? And I work on very specific subset of issues. We look at access to medicines. We look at, we really recently released a report on secondary patenting for cancer medicines. So we looked at kind of 24 cancer medicines in South Africa, looking at what kind of patents were there, was it just for the primary compound, was it for modifications, and how did those patents affect price, which in turn affected access. We found, I think, 72 secondary patents on those 24 cancer medicines. Of the 24 cancer medicines, only 7 were available in the public sector. The public sector, of course, serves 86% of the population, right? So this means that a vast majority of cancer medicines that we looked at were not available in the public sector. And there was kind of a direct causal relationship, right? Because you saw that there are all these secondary patents that are preventing generic competition, which in turn, leave the inflated prices in place. And so that's just one kind of sliver of the costs, right? And so if you look at the benefit then, if the benefit is just disclosure and invention, does that really measure up with what the costs are to society? And we're just talking about cancer medicines. Think about all the medicines in South Africa that are under patent. Think about, for example, DRT medicines, which are 10,000 rands for a course of treatment, right? You have a massive amount of influx of public resources. The government spends millions and millions of rands on these medicines, and all that money is going straight to J&J, right? It's going straight out of South Africa. And that money could be used, if you look at the opportunity cost of that, which even increases even more, because then you start looking at, we could have used that money that we're using for TB medicines, we could have used that to trace contacts, we could have used that to hire more doctors, we could have used that to do all kinds of things. But the decision that we made as a society is that we're going to send that money to New Jersey because we think that Johnson & Johnson somehow deserves it, And so when we look at the intellectual property system, I understand that there's a certain list of benefits, and we talk about those, and I think this paper does a good job of eliminating one of them. But then it's always a measure of cost and benefit, and the cost can never just purely be economic. You have to look at kind of what South Africa is, and where it is in its developmental status.
Thanks, Zane, for those remarks. So I'm going to do the following. I'm going to hand over to Mr. Lahom to briefly address Professor Clark's question. Then I'm going to hand over to the panelists to answer Biolo, who asked the only other question.
Thanks, Maru. That is my problem, I guess. I sit with that headache. I think that, and it's part of the things that we're trying to address in our strategy going forward, is that we want patent information to be accessible to the public, and extensively so. So for whatever purpose that you need to use that information, it should be readily available. But it's unfortunate that, you know, up to 2012-ish to 2013, our processes were pretty much manual. So we're dealing with paper files. Half the time you can't find the files, you don't know where the information is, and so forth. And in 2013 we moved to automate some of our processes, which meant that information became available electronically. But not all information is available electronically because our processes are not fully automated. But we are in a process now of actually automating our processes, which will make the system more easily accessible. And again, we emphasize that patent data should be available because the other reason we want it to be available is we recognize the value of patent information in stimulating innovation. If you see a US patent and there's no South African equivalent, it means that the technology is free to use in South Africa. And that is extremely powerful for any startup. They don't have to go and reinvent the wheel. So patent information can be extremely useful for stimulating local innovation because the information is readily available. And maybe just to address the question that or the comment that you made, it's not unique to South Africa, the fact that SMMEs struggle to participate in the intellectual property landscape. This is a global phenomenon. We were in Vienna 3 weeks ago. Same problem. We're in Serbia, same issues. And they also recognize the value that intellectual property information has to stimulate and to grow in the economy. And they've put quite a lot of emphasis in making sure that the public can access patent information. So going forward is going to be a huge initiative. Part of our initial drive is to make sure that patent information is accessible, but also to emphasize more on education around the IP system in general. Because we talk about, we want to become a knowledge economy, but countries who have knowledge economies are not industrially intensive because they sell knowledge. And we can't be saying we want to become a knowledge economy if we're still saying that we want to build and dig things out of the ground. We have to start thinking about beneficiation. We have to talk about Internet of Things. We have to talk about artificial intelligence. That is knowledge economy. And patents can be a very rich source of information about the knowledge economy because they are people who are in the curve ahead of us. And we can learn so much more from them than trying to reinvent the wheel and try to do our own things and basically follow them. We can leapfrog innovation in the sense that we can use what other people have done and actually grow the economy in that way. And to answer your other comment about is the policy or the thinking to include the fourth industrial revolution, and it's a problem that it's even bigger in first world countries because it's like ahead of us. But one of the things we're grappling with now is we need to hire more examiners so we can do examination. Now, in other countries, they say, what are we going to do with our examiners because of artificial intelligence? Because you'll now be able to file your application and a computer will do the search. So you have actually no use for design plan in the future. So in drafting the policy and in drafting our legislation, we have to be cognizant of these things. But the big emphasis from our perspective is that the payment system has to be accessible to everybody. Innovation must be accessible to everybody. It can't be for a specific few or for a club. And that knowledge must be accessible to everybody. That is the only way we will ever grow this economy. And we have a very useful tool in patents in that it's not the only thing. Obviously, there's other things that we have, as government, we have to put in place. But it's one tool which we can use effectively to ensure that we promote innovation and we grow our economy and we give access to our SMEs to participate in the knowledge economy. The policy, I think, allows us that space to be able to do that. Of course, the implementation is going to be very difficult because we have to balance the interests of various parties. But I was mentioning earlier today, South Africa is in a very fortunate position that we can learn from the mistakes that other countries have made. We can take the good that other countries have made and come to a very balanced view on how we look at intellectual property rights for the public health, for innovation, to ensure that we have a very balanced IP landscape that encourages innovation, that encourages investment, and encourages economic growth. Thank you.
Thanks, Mr. Lemon, for that very comprehensive answer to a number of questions. So, ladies and gentlemen, we are out of time, but I think I'm going to allow the panelists to give the final word in terms of any specific point that they want to raise in conclusion. So I'm going to start with Dr. Barrow, and then we'll move to my left.
Well, yes, I haven't got much in the way of comment to make, other than to say that we seem to be moving a little bit off the point, which is that that the patent system does not encourage innovation. We're dealing with just about everything else. And that's understandable because it's a very wide-ranging subject that we have here. But yes, I agree that knowledge should be made accessible to all that can possibly be made available to. It's said that the United States Patent Office is the repository of 80% of the world's technical knowledge. That's really saying something, but that's all there. If you need anything, you need to know something about just about any subject, ranging from a mousetrap to a nuclear bomb, you'll find it in the United States Patent Office. That's really what I would say, I think. Thank you.
Thanks. I don't believe I've got any further comment to make. Thanks.
Thank you.
Thanks. I'm mindful that I haven't had a chance to address many of the points made both by Alison and Turp on the specifics on the legal part of the paper. I must say, a lot of what I heard Alison say is that there's a yes but, and then to provide me with provide examples of actually in practice, this is how this wouldn't happen or that wouldn't happen. Well, if that is the case, then the kind of amendments that certainly could address some of what I still understand to be concerns would therefore not be, ought not to be controversial. Great, I can maybe work on this in the next round. But the point I want to make about that particular section of the paper is that what it looked at was to say, let's go beyond all of these substantive issues that we ordinarily consider when we look at whether or not there's a need for patent law reform. So let's, as important as they are, the issues of should you have substantive search and examination, what are your patentability criteria, what are the grounds upon which compulsory licenses should be granted, how easily should they be granted in terms of what processes. Those kinds of substantive issues, those substantive issues, in my view, the way our current Act is structured, are heavily skewed against the public interest. So what we tried to do is say, let's take that as a given, but then let's also look at some of these other issues that are not ordinarily considered, which make it more difficult for the status quo to be disturbed in any meaningful way. I think it's still on balance. I accept some of the ways in which the patent system may place some barriers in the way of patentees in securing patent protection and enforcing patent protection. But I do think that on balance, it still is heavily skewed in favour of the patentee. But certainly, I'd welcome a kind of engagement beyond this on those legal issues, and if we can have, if anything, if that part of the paper spurs a debate that goes beyond the normal kind of substantive issues, then I think the paper's been successful. That part of the paper's been successful.
Thank you very much. I'll also try and be brief because now I'm the only thing standing between you and drinks and snacks. Our motivation to work on this subject, and I'm very grateful that Jonathan and Andrew did so, was to examine very seriously with data the idea that more patents equals more innovation. This is a standard assumption in economies, in governments, in societies. The more patents you have, the more innovative you are as a society. That line of thinking is not only not borne out by data and evidence, it is also a line of thinking that can lead to policy results that are disastrous in terms of the cost that they levy on, especially societies in poor countries. I think that a very justifiable way to evaluate innovation and intellectual property, I do believe goes back to a point that I made right in the introduction, which is to look at who's being paid and who's paying. And an honest look at the South African patent system has only one answer for both of those questions. We're paid. And there is a group of people who are being paid, and they're not in South Africa, and they're multinational pharmaceutical companies. And I think that justifies every clear understanding of how one can reorient this system to more equitably serve the people it's intended to. Thank you.
So, ladies and gentlemen, with that, I've got the pleasure of closing. I think we can summarize by saying that this is a very important study in that it actually makes a very important contribution by providing information in a local context that forces us to ask some difficult questions and challenge assumptions that we have considered to be axioms. And I think it's a very, very important step, and one that I hope other researchers will follow on. So please join me in applauding the panel and yourselves as well.
Cheers.